activity 63 is one of the, maybe the most difficult activity in the book, so let's do our best to understand its material. It has to do with the right to privacy and the 9th and 14th Amendments. We're going to focus on the case of Griswold versus Connecticut here of 1965. It was a really pivotal case. It had to do with a law of the state of Connecticut that prohibited women essentially from using birth control pills. You could prohibit disease by certain devices, but not just conception, as the birth control pill or forms of birth control like that. So I want us to just kind of patiently look at how the Supreme Court arrives at its decision. The decision it arrives at is that Connecticut can have this law. But let's look at how they achieve it, and one thing to keep in mind is that at this point in 1965, the Supreme Court has, up until this point, limited itself to only seeing within that word liberty in the 14th Amendment some rights that are in the 14th Amendment. So they're going to try to find some rights that are in the Bill of Rights. So it has to be found somewhere in the Bill of Rights to be in that word liberty in the 14th Amendment. And so notice the extent that they need to go to try to talk about birth control pills as something that's in the Bill of Rights somewhere. So let's see what they say. Coming to the merits, we're met with a wide range of questions that implicate the Due Process Clause of the 14th Amendment. So just think, first of all, that it's that word. It's all going to come back to that word liberty in the 14th Amendment as a way of getting rid of this prohibition in Connecticut. They go on to say, the foregoing cases that they have discussed suggest that specific guarantees in the Bill of Rights have penumbras. Notice the use of this very unusual word, and I've provided in parentheses the definitions. The penumbra is a partial shadow, and this typically is used when talking about an eclipse. And these penumbras are formed by emanations. An emanation is like a ray of light coming out from some luminous object, some light-giving object. So there are penumbras formed by emanations from the guarantees of the Bill of Rights that help give them life and substance. And the next paragraph, they're going to focus in on the Fourth Amendment, although they're really talking about all the amendments in the Bill of Rights, but as having these penumbras and emanations. But focusing in on the Fourth Amendment, which, just to remind you, has to do with, most people are aware of the need for law enforcement to have a search warrant before they search your apartment, your house, your car, etc. And this has to do with the idea that the federal government, when it's engaged in a criminal prosecution and is gathering evidence with which to convict you, perhaps, this is putting a significant obstacle in the way in the evidence-gathering phase. This is a way to protect us, protect innocent people from being deprived of life, liberty, or property by being executed, imprisoned, or fined for a crime they did not permit. It's making it a little harder for the federal government to gather that evidence, especially in ways that could incriminate an innocent person. So the Fourth Amendment, as it was understood by those who ratified it, was to protect, again, the basic rights of life, liberty, and property. But notice how the Supreme Court is handling it. In Mapp v. Ohio, which is a case from 1961, we saw the Fourth Amendment says the Supreme Court is creating a right to privacy. So just notice that as far as the Supreme Court rulings go, that this idea of a right to privacy is something that is about as old as I am. I was born in 1962, so this is just a little bit older than I am. So it creates a right to privacy no less important than any other right, carefully and particularly reserved to the people. And we've had many controversies over these penumbral rights of privacy and repose. So notice at this point what the Supreme Court is saying, again focusing on the Fourth Amendment, they're treating the Fourth Amendment kind of like it's the sun. And they understand very well that the Fourth Amendment it has to do with search warrants and gathering evidence, etc. But they're saying that if you regard the Fourth Amendment kind of like the sun and think of it as giving off rays of light, all around it. Then imagine that there's the moon here, and treat it kind of like a solar eclipse, so that in between, I guess, the Supreme Court and the Fourth Amendment, there is this moon, and then there's a penumbra formed by the moon getting in the way between the sun and the observer, the Supreme Court. And in this area that is partially lit and partially shaded, giving off kind of an eerie glow, there is a right to privacy in there, is what the Supreme Court is saying. Then it goes on to say, in that right to privacy, there is also, reading the next paragraph, these cases bear witness that the right of privacy, which presses for recognition here, is legitimate. The present case concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. It's older than the Bill of Rights. Marriage is intimate to the degree of being sacred. I just realized I mischaracterized the Connecticut law. It focused on married couples. Is the focus here. A married couple can't use birth control pills. So they're saying, Supreme Court is saying, I guess with the, it's going to make fun of it a little bit here, superpowered telescope, you can see this right to privacy and you make it a little stronger. And within that right to privacy is marriage. And within that right of marriage, even bigger, more powerful telescope, there's the right to use birth control pills. So this is how the Supreme Court went about trying to justify its ruling. It does get a bit preposterous, I would suggest, to use this kind of language. They felt like they had to because they were limited so far in the ruling since 1925 to having to find the rights they wanted to get power over. It's somewhere in the Bill of Rights or somewhere. I don't think you can even say that this implies the right to use birth control pills. It's somehow in a penumbra formed by an emanation coming out, and that just seems not to really mean anything logical or sensible at all. But you can think about that yourself. But I feel confident in saying that because when we get to letter D, you can see that Justice Goldberg also, I think, seems to have found something questionable about that ruling, which is why he starts bringing in the Ninth Amendment in a concurring opinion. I want to get now to thinking about what the Ninth Amendment was put in the Constitution for. The Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This simply means that the rights listed in the Bill of Rights is not complete. It's not a complete list. There are other rights. It's a list of some limits that were put there because it was deemed especially important to be clear in these areas, but that doesn't mean that there aren't other rights. And another way to put that is that we're making a list of limits on the federal government. Let's not get the idea that these are the only limits on the federal government. There's lots of other limits on the federal government. Specifically, Article 1, Section 8 is a limit, and they can't go beyond that. So there's many, many rights that are outside of federal jurisdiction that are left in the hands of the state governments. That's what the Ninth Amendment means. That's what it meant to those who proposed it and